Jerry.
Madam Chairman, I request that the board defer discussion on item 7B until council has the opportunity to brief the board on a matter of the remaining matter of existing litigation that impacts this item.
And that brief would occur today, is that correct?
Yes.
Okay, just to be clear. Is the board comfortable with that? Okay.
Yes, I am. Holly Heinzen with the County Executive Office. This afternoon, we are requesting that the board consider a proposal from the developer of the Regional University Specific Plan for a specific plan fee and reimbursement agreement between Placer County and the developer. As you know, in 2008, the Board of Supervisors approved a specific plan that proposes a mixture of land uses on 1,158 acres. It would include 4,387 residential dwelling units as well as community space that would be used as a town center. In addition, it proposes acreage for construction of a new university. The reimbursement agreement that has been proposed in general identifies how the fee would be applied, and a couple things. It would be applied on any persons filing an application with the county after adoption of the specific plan fee. It would not include any land designated for open space or designated for open space in any modification, and wouldn't apply to county-initiated actions. The basis of the fee would be the incurred cost for preparation of the specific plan, basically the entitlement costs. At this point, that's been identified at $9,380,832 to be precise. Additional costs could be added as they were incurred by the landowner from and after that time of approval. The reimbursement amount would be subject to interest. And I believe the original proposal was from 2003. I believe there's concurrence that it would be if this specific agreement were approved, and the interest would be calculated at the prime rate plus 2% or 6%, whichever is lower. It would be applied on a fee acre basis and or an equivalent dwelling unit basis as determined by the county. The county would collect and administer the fee and provide the landowner each year with an annual accounting of the specific plan fee. Essentially, the fee would be used to reimburse the developer for specific plan costs, the cost for development of the EIR, fiscal studies, and other costs associated with entitlement. Ultimately, the fee ordinance that would need to be adopted in order to enact this would be paid by future homeowners on a per dwelling unit basis. Initially, we think it's about $2,140 per unit as a very preliminary, rough, plus or minus sort of thing. I think you understand that there's outstanding litigation that might be added to that. And I would note that approval of a reimbursement agreement is fairly common in Placer County for infrastructure plans and services. We have not heretofore approved reimbursement agreements for entitlement costs. Basically, the premise that the board had concluded some time ago, and the policy that that's based on, is that the entitlement costs are typically included in the value of the land. Obviously, this is a complex project, and there are other issues surrounding this, so I think it does deserve consideration. I wanted to make sure that you understood the difference between reimbursement agreements that have been approved by the county or administered by the county and what's being proposed here today. With that, I'm happy to answer any questions. I will note that there are still a number of outstanding issues relative to this proposal, and we have not concluded a negotiation. I think really the question is, does the board want to enter into a reimbursement agreement, and should they so desire this specific reimbursement agreement, we would look for direction as to that reimbursement agreement. Council is here who has worked on specifics of the reimbursement agreement, and we're happy together to answer any questions that we can.
Supervisor Duran.
Yes, I'm going to start out by saying, unfortunately, I did not get this until yesterday afternoon, so I, just like you, haven't really gotten my head fully wrapped around this. But one of the concerns that I have is, in just reading it briefly, was the statement that you just made right now with regards to our ability to request reimbursement for infrastructure as a for other developers to then heretofore request the same type of situation as we're contemplating here.
Yeah, it could set a precedent, and I think that would be something this board would need to weigh in their consideration of this particular item.
Okay. And again, we haven't thought through all of the permutations of that.
Right, this reimbursement agreement in and of itself actually is, fairly straightforward, but there are tentacles that I think we would consider as we move forward on it that are relative to the number of other documents that are related to it.
Okay, thank you.
Supervisor Euler?
Yeah, to Supervisor Duran's question, obviously in this situation, what's different from any other project, the vineyards or what have you, as the projects sell off to individual home builders in the vineyards, the landowners are going to be pricing it based on their cost of land acquisition, their cost to bring the entitlement, and whatever profit margin they choose to achieve, and then hopefully that's sustainable in the marketplace, and they haven't priced themselves out of the market, otherwise they're going to be holding on to their land for a while. In this unique situation where the project applicant has offered this piece for donation for the purpose of building a 4-year university, they won't have the opportunity to utilize that mechanism to recoup their costs of bringing this opportunity to fruition, because they will not be selling it off, which is where they would normally recoup their cost of the entitlement process. So in the future, could somebody come to us and ask us not only for a reimbursement agreement for infrastructure costs that they up front, that people come on, but also for entitlement? Could they? Yes, they could. Clearly discretionary by the board, but more importantly, what are they doing by layering fee on top of other things to then price themselves out of the market and not have a competitive project that they then sit on for quite a while? I mean, really, one way or another, the market will work itself out. The difference here is that by virtue of what was intended with this project, which was a donation, the project applicant, the developer, will never enter the marketplace for that opportunity to begin with, hence the reason for this being brought to the board.
Yes, and I do agree with you, and I understand that. I was really clarifying what the county practice has been, and whoever ultimately develops this property, regardless whether it's a private nonprofit, the county, or the myriad of other entities that might want to pursue this type of project, there are burdens on the project that will be inherent in their cost to develop. So this will be one of those costs, basically.
And just quickly, if I may, Madam Chair, follow up on that. Holly, well, Placer County hasn't done it. Are there other jurisdictions that have done reimbursements for the entitlement along these lines?
Yes, and I know Sutter County has just, was it Sutter? Sutter County
Yeah.
has just entered into agreement that is similar but not alike in terms of a situation.
Similar but not
I don't know that it's directly, it's similar, but it's not the same.
Okay.
And I do know that there have been a couple others. It's not typical in the region, I would say. And when it has been done, and I know in the case of Lincoln, who recently approved a reimbursement agreement for entitlements, it would cover more than one developer and who own the property as it's going through the entitlement process, and one developer is fronting the money. So it's a little different in this case, but not, I don't think it's a...
In this case, that's precisely what happened. I mean, in this case, you have a number of different people who comprised the 1,300 acres, but the cost burden of entitling the project and creating the opportunity was actually borne by just one of the property owners. So the example that you gave of
And it
Lincoln,
would
this
go
is exactly the
exactly
same
back,
thing. Yeah.
since it's a donated piece, right? Yeah, so that's out there for your consideration. I'm
David, your light's on.
Oh, sorry.
Okay.
Didn't mean to.
David didn't want to talk. Robert?
I have a concern about the interest rate. Strikes me that if the goal is to preserve the cost of capital, we would adjust that amount for inflation only. So prime plus 2, is it? Or 6%. At 6%, the $10-ish million would be about $20-ish million in about 12-ish years. And it's finance perspective, it seems like the contribution would be making money on the interest at that rate. So do you have any thoughts on that or reaction to it? Or
Well, I think that is something the board needs to consider, the extent to which the capital is preserved over time, because that ultimately is what is of benefit to the project, right?
Right.
It's the donation.
But I mean, just on the thought of prime plus 2 sounds to me like it's doing far more than just preserving the value of the capital.
Right. And I do understand the desire to keep pace with what the
Inflation.
cost, inflation and the cost of money, so maybe that would be a good way to treat it.
Okay.
Supervisor Euler?
Oh, yeah, I'm looking at this without having the conversation, tying things, obviously, but I'm looking at this trying to preserve what I think is a great opportunity for the county that the board voted for a number of years ago. And I'm going through the mechanics of it, and I guess I keep coming back to, okay, why wouldn't we? Why shouldn't we? Where do we put the county in jeopardy in this kind of a situation if we're simply acting as largely just as an administrator of a reimbursement like we do right now? We have mechanisms in place. We have policies and procedures in place in a number of areas for reimbursement agreements that we officiate, if you will. And so help me understand where's the pitfall for the county in a scenario like this? How would we be creating jeopardy for the taxpayers if we were to enter into some kind of a reimbursement agreement?
Well, and actually, Supervisor Euler, I don't know that it would create jeopardy for the taxpayer. I think one of the evaluations that should occur is the fiscal perspective of what implications it might have in pursuing a university project ultimately. Do I think it's a fatal flaw? No, I don't. The burdens on this property right now are about average for the region based on 2 different studies, one done by Roseville and Wildan and one that we did actually several years ago. So the existing burdens are about average for this property. This entire board knows that there is a huge push not to increase the burdens on these properties, in fact, reduce them substantially. So I think part of your consideration needs to be, what does it add? You know, is it palatable? I would say we haven't done a full fiscal analysis. Maybe we don't need to. I agree with you, there's not a big risk to the taxpayers. I think there are some implications for it that are not entirely defined at this point, because there are specific planned costs that are unknown at this point. There are obviously legal costs that are unknown at this point. So there are just some unanswered questions. I think we avoid any risk to the county or the taxpayers, and if that's what you thought I was saying, it truly was not. It's just, I think that's what the board needs to weigh at this point.
I appreciate that, and to take it a step further, again, as I mentioned earlier, when if I'm the developer and I'm taking this through, I have my land basis which I need to recoup, I have my cost of entitlements which I need to recoup, and hopefully, God willing, I'm able to make some money at the end of the day. So I'm figuring that profit margin in and what I'd like to get, but then the market's going to dictate what folks are going to pay for the land. So I have those 3 components that are the cost drivers that say whether or not this is feasible for me. In a scenario where a project is donated, the 1,300 entitled acres are donated to a third party, a Drexel University, a local government, this fee becomes the only cost basis that would need to be recovered. Everything else is quote-unquote profit to that entity to which the donation was made. Everything beyond that, because I have no land basis, I have no carrying costs, I have no profit motive. So whatever the ultimate end goal is of that nonprofit or government entity that might ultimately absorb that project, if this fee exists, it is the only cost that has to be paid. 100% of everything else essentially becomes profit for the purpose intended by virtue of whatever that donation achieved, correct?
Well, I think with some caveats in terms of the need to invest in the infrastructure. So, I mean, it's not pure
Well,
profit,
it becomes the mechanism that you then use to invest in the infrastructure.
Absolutely.
But what I'm saying is, but you're getting at nothing more than the cost. In other, I'm home builder X, and I go to developer Y and I say, I'm going to offer you this much for your lots because it's paying you for your dirt, for all these other things. Now I'm home builder X, I'm coming to Drexel University or some other third party or government entity, and I'm saying, I'm offering you this much. Well, only this much actually has to go to pay the fee,
You know,
and everything else goes to
I
achieve
so
that.
much agree that it is a donation, and it certainly becomes profit. In order to develop these lots, there will be a cost associated with developing the lots, and this merely becomes part of that cost. And it's right now at about, I'm going to say, $87,000 per door, and you add a couple thousand on, and that is just part of what it ultimately could cost to move forward. So I think the question that needs to be weighed, and I don't think it's out of line, is that commensurate with other projects? Is it reasonable to think that will develop? To what extent do you look at this over time? In terms of this agreement, the outstanding issues are the 30-year time frame with automatic extensions to the additional costs that can be added over time, both in terms of interest and in terms of new specific plan costs. So I think that whatever Drexel's obligations are here, is the balance profit to put into the university? Yes. Do I think that will be there? Yes. So it's not that I don't think it will be there. It's disclosing to the board what is included and what we would be looking at in terms of an agreement that looks at maybe putting some sideboards on total costs or total reimbursements.
Sure.
Maybe looking at having, if the board so chose to move forward, looking at how you keep the value of the money but not necessarily earn interest over the 30-year time frame. I mean, I just think there's some of those outstanding issues that the board would want to consider should they want to do a reimbursement agreement in this case.
Supervisor Wygant?
Yeah, I agree with all that. There's really good dialogue, but I think it reflects a lot of information that we should research. I mean, Kirk, you made a great point, I think, in the sense that, you know, if we were all doing this project and looking to make money at the end of the day, would incur all of our costs, that would make our sales, and hopefully that gap would provide a viable return. And since we're getting it given to us and we're not in the profit business, you know, maybe it would equalize and work out just fine. But the market's changed so much, and it's also not my expertise. I think it would be intelligent to strategically look at those kinds of details and see where it puts us, and see what it does to our strategy to make this whole package work the way it's intended, along with the interest rate situation.
Supervisor Duran?
Yeah, I was just going to say, you know, I don't disagree with the process and the agreement. I just don't feel that comfort level that we're actually there yet, hearing you say that there are still some additional things that we need to consider. You know, that doesn't mean that we can't get there, but I think trying to make that decision right now with those unknowns makes it really difficult. So I would suggest that we kind of put this up for a short period of time to provide the opportunity to get that data. We don't take a whole lot of time, obviously, because we know that there are some time constraints that we're under, but to provide staff the ability to crunch those numbers and bring it back to us. So that's my thought.
Supervisor Euler, your light's on.
Oh, yeah, I'm sorry. So just
Deep in thought.
yeah, to clarify, and we haven't heard from the applicant or proponent or whatever we want to call them. So I guess at this point, if we may, that would be great.
Yeah, I had just a couple of quick clarifying questions before we hear from the proponent or the applicant, whatever we're calling them here today. So if I understood what you were telling me correctly, Holly, there's a couple of fairly critical, from my perspective, pieces that we really don't have a handle on yet. What is the total dollar amount that's being requested? Because it's not just what's accrued to date, but additionally some dollars that may come forward in the future.
Yes.
Okay.
Yes.
We also, getting to Robert's concern, we don't really know what the interest rate is we're talking about. We know it's either prime rate plus 2 or at 6%, whichever is the
And that's
lower.
what their proposal is.
Yeah, okay. But then we also don't know the time frame. Robert ran it out for 20 years, but you mentioned 30 years. What does that do?
The term of the agreement is 30 years with automatic 10-year extensions. And I'm going to kind of look at counsel who's somewhere behind me. I'm pretty sure that's what it says, something to that effect. Maybe Tim can clarify that. Oh, they're not automatic anymore. We received a new agreement last night, so there may be some tweaks on it.
Okay,
Not automatic extensions, so 30 years.
okay. All right. Any other clarifying questions before I have Tim or Julie come forward? Do you want to come forward?
Thank you, Chair Montgomery, and members of the board. Tim Tarrant here on behalf of the Skopolis family. Let me start by trying to put this in context, because I think we lose context. This is a family that's trying to give away 600 acres of land for university and 3,000 approved residential units. They want to give that away. They spent $9 million getting there, and the only thing they want to get back out of it is the $9 million that they already spent. They're going to give the rest away, and they have a passion to give it away, and they want to do it here because they love this community. They've worked for decades in this community, and they really feel like it's something that is a legacy that will be great for the county and also good for them, but only good for them in an emotional way, not economic. This is a break-even proposition for them. Frankly, even getting this money back is a losing proposition, because I can tell you their cost of capital is more than prime plus 2. And their opportunity costs of their money is more than prime plus 2. But we can talk about that. That's not a deal breaker. So that's number one. Number two, despite my protestations, your counsel, I think, has guided you in a way that we are willing to accept to the language that's in this agreement that was sent out Friday to us. We responded yesterday, but the agreement that the county was proposing came out on Friday. And it says that your obligation under this agreement is to consider adoption of this fee. It's not binding on you to do that. Once you get all the costs back, your audit of the costs, some of these other questions perhaps answered, and we've got about a 90-day time frame on that to do that. So you have that process because of the way this agreement. And I actually asked my tax advisors this morning, I said, can I actually say that in public? And they said, yeah, go ahead and say it because it's the truth. They said it is what it is, okay? So there is that process in place. As far as what kind of precedent this sets, I suppose you could say it's a precedent. I mean, it's a precedent from the standpoint that it's on a project that has been committed to for donation. That's always a distinguishing factor. But aside from that, I would just say we have done this repeatedly in Roseville. Lincoln just did it. We just did it in Sutter County. I do it as a land use lawyer everywhere throughout Northern California. It is a process that's authorized by the government code because they recognize that usually the people who are out in front on any kind of a large master plan, specific plan, usually advance money that benefit other people somewhere down the line, and it's appropriate for them to recoup those costs on a reasonable basis. So it's not a bad precedent. It's one that the government code authorizes and says, even the state legislature has said, we recognize this need and we're going to empower local agencies to do this. Yes, it's typical. It's fairly typical that it covers more than one developer, but it's not atypical that it's only one property owner. And for the reason Supervisor Euler said here, it's particularly appropriate given the fact that this family that put out this money is not going to have a chance to recoup any of this down the road in ways that it otherwise might be able to. The additional costs, the additional costs, honestly, that could be incurred in this project on the part of the family, as I see it right now, we have one more permit process to go through in order to be able to have a university go vertical, and that is we need to get the 404 permit. And we might be advancing money to do that. So it would be fair and appropriate to add that. But that's pretty much it. Anything else probably would be some successor in interest, hopefully the university or the entity that develops the university. I did mention from the audience, there are no automatic extensions anymore. We proposed them. Actually, they weren't automatic. They were automatic only if one side or the other objected to them, and then they wouldn't happen. But your council changed that to say no extensions unless mutually agreed upon. So that's already addressed in the version that your county council has drafted. One last technical point. In the version that your council has proposed, there is language that says that all of this is contingent upon we being successful, we being the landowner, and the county being successful in the litigation that is still pending. We responded yesterday and asked that that language be deleted from the agreement because, as I think most of you know, if you didn't know, there's some charitable intent associated with this on the family's part with getting this done this year. And if you have that language in the agreement, our tax people say that's a contingent type of liability that that doesn't work for us. We would like that language deleted. The litigation is still there. The landowners have an indemnity agreement with the county to reimburse the county for costs associated with that litigation, separate and apart from this. So we're asking that that language be deleted consistent with the version that I sent to county council yesterday. I think that's it. Julie, did I miss anything? Okay, thank you. I'd be happy to answer any questions you have. And by the way, thank you all, and thank you to your staff for entertaining this over the past 45 days or so. Very much appreciate the effort that's gone into this. Thank you. Okay.
Thank you.
Madam Chair.
Supervisor Euler.
Tim, two things. First of all, the issue of the resolution, the litigation, that writing with this, to my way of thinking, the fee only gets imposed upon development, and the development doesn't happen without the resolution of the litigation anyway. So why, why would we need to have, and maybe I'm looking at Jerry, why would we need to have the resolution?
It's a statement that I didn't want to make publicly, but since you made it, I will confirm what you said.
Why would we need to have the statement in there saying that you have to get the litigation taken care of when this is a fee on development that can only occur if, in fact, the development's been taken care of?
Thank you. That's correct.
I mean, if the litigation has been taken care of.
Yeah, most of our comments initially were directed toward the additional costs that could be incurred as a result of the litigation by whatever court order might have been to impose additional requirements and therefore additional costs. And it seemed like something that the agreement already covered additional specific plan costs, and it just seemed like another cost that
Yeah, and counsel, to the other aspect of that is to the extent that family members make charitable contributions of their rights under this gift, no charity's going to accept it if they're thinking that they have a liability associated with accepting this gift. And so that's the other reason, honestly, that we want it out of there. We have the liability in a separate indemnity agreement with you. There are no, so that's inside the Beltway discussion, technical in the weeds stuff, but it's important to us.
But that does lead me to my second question, and please feel free to step on me and stop me if I run afoul of anything that would violate the issue that we addressed when we approved the university to begin with, and that was that we cannot obviously tie any kind of a donation to a project approval. We didn't in the university, and very clearly Mr. Sikopoulos and the ownership group did make good on their commitment to make a donation. It has been represented that it is the intent not to recoup these dollars to put them back into necessarily the owner's pocket, but to then be able to further make an additional donation when those dollars are recouped, to make an additional donation to other nonprofits in the education area. Now, I'm not going to ask you to say anything that would violate that whole issue about tying one to the other, but to the extent that you're able.
Well, to the extent I'm able, you are correct. If it were a condition of what you're doing, that would be fatal. I can only say and will only say that there is obviously there is a charitable intent on the part of the family associated with what we're asking you to do here today.
To be reimbursed the costs, and their charitable intent is to take the dollars that they get reimbursed and make additional donations to additional nonprofits, some of which may very well be right here in Placer.
I can't speak to that.
I know you
okay.
can. I appreciate that.
Okay.
But I've had enough conversations with others in Placer County that I know that. But I know you can't say it.
Supervisor Duran?
Yeah, Tim, I want to thank you for clarifying that that piece about the 90-day window. I figured that I assumed that there was some time to kind of get through the calisthenics of this. And please, I want you to convey to the family that we do desperately appreciate the fact that they're willing to make this donation. And I understand that the code does provide the opportunity and incentive for people to give property to county, cities, whoever, nonprofits. And
So far.
and it's very important that we do that. All I'm saying is I'm not in disagreement with you on any points at all. All I'm saying is that I'm getting the feeling that we need to just take that time, so to speak, to kind of cross all our T's and dot all our I's.
And I guess my question to you, Supervisor Durant, is that by approving this today, how are you prejudicing your opportunity to do that, given the way your counsel has drafted this agreement today? I don't think you're prejudiced one bit. You have to retain, and your counsel has advised me, you have to retain your legislative discretion in the future. So, on the other hand, it means a lot for us to have you do this today with the edits that we've asked for. But what you do 90 days from now will still be up to you to do or not do, or in what form you do it.
What does it mean when you say you asked us to consider? In other words, specifically, what kind of action? I mean, we are considering it right now.
Right. Well, no, you're not, because it is actually to adopt an ordinance imposing the actual fee.
Okay.
After the costs have been audited, you have an exact number, you have an exact fee, and you have an ordinance in which it will be embodied, along with whatever interest rate you decide to or not to
So could we then conceivably adopt the ordinance today pending a 90-day review?
Well, you don't have an ordinance before you. It's not been noticed for that, so you can't do that.
I'm sorry?
You can't adopt an ordinance today. It's not before you. It's really...
Oh, so then that's what's the purpose of my question. What are we being asked to consider?
Well, your counsel knows this.
To meet your tax
because
obligation.
what I was able to do in Sutter County is actually this agreement where it didn't say to consider. It said the board shall and agrees to adopt a fee. And your counsel said, we don't think that I'll take words out of their mouths, you guys correct me, we don't think we can legislatively or contractually restrict the board's legislative authority in the future, since they're not actually adopting the ordinance today.
Can we condition it? The board shall adopt within 90 days a fee that does this, assuming,
No,
Yes.
you know, Supervisor Yule, I appreciate that, but we're past that. Your counsel came back to me, and just because I need to keep my integrity intact, he said, would you agree to this language where we said, no, the board will consider it in the future, but we can't make it a binding commitment? And I said, if that's what your recommendation is, I'll talk to my client. I talked to my client and said, we will agree to that.
okay, so I apologize. I guess I'm still not clear. You're asking the board to consider it. I don't recall in 10 years, and maybe Robert's done it, I don't recall ever making a
Well-
motion saying, I move that we consider it.
No, you're approving this agreement, which language says you will agree to consider. And honestly, it starts a process that commits your staff to some time,
Okay.
us to some money.
Okay.
There's a process you're agreeing to in this agreement
Okay.
that you do have to uphold. You have to agree to take all our costs, look at them, we have to pay for that, and then bring it back to the board in the form of an ordinance, which then the board decides
So then
whether it will
the
do.
action, taking action on the ordinance is then presumed to be deferred to some date in the future.
That's correct.
What we're essentially doing is laying the groundwork. If the board were to direct staff appropriately, we would just be laying the groundwork for the actual adoption of the ordinance. But what we're managing to do is in fiscal year 2012, in tax year 2012.
Tax year 2012.
In tax year 2012, not fiscal, we are actually setting the wheels in motion that your tax folks say, it helps.
That's right. We're willing to consider this on the terms that are in this agreement. We're willing to consider it, and we promise to bring it back within 90 days or whatever the period of time is, and decide up or down or side.
Would you clarify?
I feel much better, thank you.
Okay?
Okay, I've asked county council to clarify from the county's perspective what the county believes this action is we're being asked to take today, so that
Yeah, it'd be
Y'all
helpful
understand?
too.
Yeah.
It's, okay, I'll start out with, it's an unusual application of the reimbursement fee, but it's also an unusual project, so I understand that part. But it's difficult for we're presented with an agreement and asked to comment on it, but without the basic policy direction of the board, that the board would consider this, I don't consider that we were negotiating an agreement with the developer. We needed the board direction to proceed in this direction and some direction on some of the key parameters of the agreement. The agreement binds the county to consider it on the terms set out in the agreement. So the issue of interest or any kind of inflationary measure is an important part of the agreement. I didn't really feel that I could comment on that and just delete it without the board's direction on that. The whole issue of future costs and future costs that will be incurred is an issue that, typically in a reimbursement agreement, the county obtains its own costs as part of the specific plan fee. So basically, all of my comments on that were deleted from the agreement, which is, and I understand the reasons for it, but I still don't have the direction that this is the kind of direction that the board wants to go in. These are the parameters that the board is willing to consider. And that is what you're doing, considering, but by entering the agreement, you're considering it on these terms. And I think staff needs that kind of direction to really say that, to represent this as somehow that council have, negotiated some agreement, I think would be misplaced. I mean, these kinds of costs are typical in reimbursement agreements. And imposition of fee is typical, but the board needs to direct public policy basis for the imposition of the fee in this case and the basis for the reimbursement agreement. And that's what I thought was missing when we're just exchanging documents.
I get it, thank you.
One response, just clarification. The future costs that we deleted from the agreement that we request to be deleted were the future costs related to the litigation, the county's costs in the litigation, not the county's costs of administering this fee. Specifically, I believe we left in and should left in, you said you wanted 2.5% of any fee to be available to defray county costs. That's entirely appropriate that stay in. So it's only the costs related to the litigation. Again, we have a separate indemnity agreement with the county regarding the litigation. It's already in existence.
Supervisor Duran?
Oh, I'm sorry.
Supervisor Euler?
Again, I come back to, I just don't see any harm in us moving forward, and I think that in the spirit of sending a message, hopefully, to others in the future that the county is looking to do what we can to be innovative, to partner with the private sector to create wonderful opportunities like university development, especially knowing that it is the stated intent, but we're not obligating. It is the stated intent that the dollars that would be used under this reimbursement were going to be regifted anyway. I am more than happy to make a motion that we ask staff to continue the conversations in hopes of bringing not in hopes of, with the objective of coming back to our board with a fee agreement that we can consider on its merits once we've answered all the questions that have been raised. Anything in my motion, before I request a second of a colleague, anything in my motion violative of anything that your tax counsel would freak out over?
No, I think the only correction might be that what we hope you would come back with ultimately for the board's consideration would be the fee ordinance, not
Yeah,
another.
I apologize. That's what, when I said come back with the fee, that's what I meant, was the ordinance that would enable us to actually do that, so.
If that,
Thank you.
if I may.
Yeah.
If that is the sum total of what we're being asked, and there are going to be further discussions, there are going to be further fleshing out of the data, the interest rate, all that kind of stuff, and this isn't the end-all be-all, then I don't have a problem engaging further or having staff to and our legal counsel to engage further, if that's what I'm hearing.
I will just say again that ultimately you have the discretion, whatever it's 90 days or not, to do whatever you desire to do. We are going to proceed, if you approve this today, to move this along on the terms that are in here today, but you have the ultimate say down the road.
Okay. Well, and that being said, I feel a little bit more comfortable about the position, so I will second that.
Thank you.
And before we go to a vote, I have a couple of just sort of concerns that I see really still looming out there in terms of this. The question was asked, is this precedent setting? And I think it's very clearly precedent setting. I agree that this is a unique request for a unique project, but unfortunately what I've seen when we have created other precedents in the past is they become the standard more than the exception to the rule. And in this case, it truly is an exceptional project, and this is an exceptional proposal, but I think it just lays the groundwork for other folks coming forward with this same request. And the concern I have with the request is the policy question about infrastructure versus planning documents and specific plans and consultant costs. And I'm not sure we've really talked about as a board, and I think it's important to have that discussion before we take action on this, whether that's even a policy we want to choose to move toward, changing the way we've done these sort of reimbursement fees. The only ones I've seen were for things like stoplights. They weren't for anything as, not to make a pun, but as regional in scope as what's before us today. I'm also concerned that County Council doesn't sound entirely comfortable with the language that's in the proposal in front of us. And so I just am, really putting it up into my fellow board members as to your thoughts on that policy piece, the precedent piece.
Well, from what I'm hearing, and listening to Supervisor Euler's motion, those are some of the things that need to be considered further, and that will be considered in the coming time for review. Correct?
Yes.
I see the motion as, a motion is answering the first question. Are we interested in considering the reimbursement agreement in this kind of context?
Right. So
that policy question
and
is answered by the motion if it's
Sure.
adopted.
And I think the lawyers in the room, not to the non-lawyers, can kind of figure out the arguments of delineating what, what is analogous to this and that, in order to kind of sew that in there. Correct?
Yeah, although there's
Yeah.
still direction to be given,
Exactly.
obviously.
I get that. So with that,
Can I ask one question quickly? It is very important to us. I mentioned the language regarding the litigation costs. I need to know whether that's in or out, because that is very important to us.
As far as making the motion, since we are covered under the litigation by separate agreement, I don't know why that would need to be in there. Does staff have a reason why, given that, again, any jeopardy to us over the next 90 days as we have this conversation before you come back to us for the adoption of an ordinance, is there any jeopardy in taking that language out?
Actually, that was a council question. I think I'm
Yeah,
probably not the right
Is there any
person
jeopardy in
to
taking that
answer
language
it.
out?
No, and in fact,
Actually.
the litigation costs were basically to cover those litigation costs. That was
Okay.
a policy issue for the board to determine. And the other part of it, there's two sides of the litigation costs, the actual litigation costs and the potential future, which is, I call future costs, potential future actions that the county might be required to take based on a result in a court. And those are the same kind of planning costs. A court could say, you need to redo the EIR
But
and
that would
address
assume the
these.
county were in a position of ownership, which we're not. So the existing indemnification as it regards the litigation associated with approvals of the project supersede, and we can take it out of this.
And that the board is not concerned about those potential future costs,
Right. And
which result from any court.
Well, any
decision.
potential future costs, you would require us to sign another funding agreement.
Right.
We always have to do that, so.
Right, or it
Those-
would require us to be in a position of having any kind of liability for those costs, which would require separate action of the board altogether.
Well, Mr. Tarrant is correct. We would go back to the project proponent
Yeah.
and get a funding agreement to
Right.
cover those costs.
Exactly.
I don't know exactly how that would
So in other words,
fit
staff
here.
sees no harm in, for the purposes of moving this forward today, taking that out.
Yeah, no harm in taking
Okay,
that out.
thank you. Then my motion would be that we remove the reference to the litigation costs as it relates to this action today. Does the second agree to amend?
I'll amend.
And Jerry, then again, before we move forward with this, I would like a clear statement of what it is that, based on that motion, we are committing ourselves to today.
All I heard in the motion is continuing to discuss the issues generally. I did not hear that we were going to be, that the board is entering into this agreement, whether in any of the amended languages that were included in the board memo, and that as those issues are developed by staff, we'll come back to the board for that additional direction that's necessary to get back to those key issues that really we don't have enough direction on to be able to present Mr. Terran with an agreement that we can say, well, this is the board's position on this agreement.
Okay, and thank you, because that's what I thought I heard as well. And maybe this is a question for Julie, I'm not quite sure. I'm not sure how this gets to the conversation we had last week where you were very concerned about something happening in 2012.
Yeah, if we don't
I don't
have,
see this getting to your concern that you raised last week.
no, and I didn't understand the motion that way, but let's clarify it. Yeah, if we don't have basically the form of the agreement that county council presented to us, we gave some edits. I think the only substantive one that we gave yesterday was this issue of removing the litigation costs. If we don't have that, an agreement along those lines, something in writing, then we don't have what we need.
So you're looking for something in writing by the end of the year?
Yeah.
For the agreement that staff presented back to you,
Right.
the only concern that you have was the issue of the litigation language.
We changed the name of the landowners from the Sokopolis Family Trust to the individual family members. We changed the names. That's not I don't view that as
Right,
substantive.
So again, just to clarify, so you have some minor modifications, you change the name, and then you ask us, remove the reference to the litigation because it's covered separately.
Correct.
Other than that, what you're asking is to provide, or to approve the agreement that our counsel referred back to you for your consideration, knowing that the agreement is fully subject to the adoption of an ordinance in the future, and that should the ordinance be presented to our board and we vote it down, then there's no jeopardy to the county and you don't get reimbursed.
That's correct. That's correct.
So that's all we're being asked to do today, is to enter into the agreement provided by council back with their comments for the request to be able to move forward for future consideration of an ordinance. Is there any jeopardy to the county in us doing this?
Have we seen that actual language?
Yeah, the county presented it.
Let me just
This is an old version,
be clear in terms of what I think county council sent back to Mr. Taryn on Friday. It was really some legal and technical
Yeah.
changes. There were a number of outstanding issues that had not been resolved, which I articulated earlier. So just so you know what was in that agreement that had gone out, it included some technical changes related to the lawsuit and a few other things. So just so you have some feel, and that it's
But Holly,
changed substantially over the last few days.
but we're being asked to approve an agreement we haven't seen.
That's probably so. Yes, that would be true.
Okay, so
And
Yeah,
that's
you saw the original proposal
the-
because we had not yet received it when this was distributed, right?
yeah, okay, and that creates some angst on my part.
You mean?
I mean, it may
they
be
didn't
a
get-
lovely document and we may all think it's fabulous, but I haven't seen it.
Absolutely, I understand, and we have several iterations in terms of what had occurred. So I think that was part of the issue in putting this forward and posting it, in that we had the proposal from the developer that had not been agreed to. So, I mean, I think that's kind of what you saw, and that was what the request from the developer
Right.
was to consider. And you know, I think there's several iterations in between, but what you received was that proposal and that proposed agreement. We have copies for you today that we received last night that include their most recent changes.
Well, yeah, we got county council, we submitted a draft of our proposal, I want to say probably a week and a half ago. We got responses, we got a revised version Friday afternoon, and I gave a revised version back to the staff yesterday afternoon.
Yeah, and
I'm sorry for the confusion in all this.
Yeah,
I think
that
my
changes everything.
yeah, it does.
My comments were, prefaced by an email in which I indicated I don't have any board authority, and there are certain key issues that we need to have the board weigh in on. It was no way, and I don't think we misled Mr. Taryn, that somehow we had the board authority to decide which provisions in this agreement we like. We tried to add some protections based on the pending litigation, and that's about as far as we got. I'll let Rob comment on.
If I could, Chair, the agreement, obviously an agreement such as this, fairly complicated. There can be a number of things going back and forth. There were some technical adjustments. The principal changes were revolving around the litigation and the capture of those future costs, clarification of a few other items. Mr. Taryn provided back those comments yesterday afternoon. And as Mr. Carden pointed out, we went into these discussions. I think it's probably too far to call them negotiations. We didn't have the policy direction from your board in terms of what authority we had. We did not have authority to agree to those items, and we're presenting it obviously in a fairly expedited time frame. A lot has happened in the last 7 to 10 days, and that brings us here today.
Supervisor Duran, your light's
Yeah,
still on.
do you have that red line?
Mr. Duran, yes, we do have the red line.
Okay.
And if I could add, one of the key policy questions that has come up today, for example, is on the interest rate or some other adjustment. And obviously, depending what the pleasure of the board today, what would be the prime plus 2 is what's included in this particular red line. But as we pointed out, we did not have the authority to agree to that. Should your board wish to use that or some other adjustment, well, we would ask for that direction if that's where you go today.
Supervisor Euler?
Yeah, I guess maybe I'm trying to simplify this too much. What I thought we were doing is agreeing that we would move forward with a defined period of time where things like the interest rate, things like total cost calculations, because standing here today, the county hasn't had a chance to review the $9 to $10 million worth of invoices to see if we would think these are legitimate invoices subject to reimbursement and all the rest, that it's in that period that we would, in good faith, have the conversations, and then that would then be codified in the form of an ordinance that would be brought back to our board, and our board at that time would make a decision. Yes, we want to impose an ordinance that imposes this fee, or no, we don't want to make a decision that imposes this ordinance. And all of this, we invested 90 days, but that's really it. Am I missing something? I mean, I'm just trying to...
Yeah, and actually, I don't know that you are missing something. I think the outstanding piece that was suggested by council were those other issues that I addressed earlier. And if your board may want to consider incorporating some of those changes and authorizing either the county executive officer or another designee to sign an ultimate agreement should you wish to proceed, or you have an opportunity for a special meeting if the end of the year is that key critical date. And so I recognize you have not seen this. It has been a little fast and furious in terms of addressing this issue. We certainly understand, and I think Kirk is correct, that your board would have the option of adopting an ordinance or not. I understand from council that there are some constraints in entering this agreement, that there would be some, you would be proceeding based on the elements of this specific agreement, is what I understood from council. And if someone heard it differently, please let me know. But I think that gives you some options for proceeding and addressing those issues, should you choose today. Staff can come back with the adoption of the ordinance if that's what
And again,
the direction
I
is.
keep coming at this from a standpoint of, are we placing the county in any kind of jeopardy? And if there were something in the agreement that we hadn't read that says that as a part of this agreement, the county agrees to buy lollipops once a year for every county resident for the next 10 years, and we don't come back and adopt an ordinance implementing that, have we created any jeopardy?
And I don't think we have created jeopardy, no.
Have we created an obligation on ourselves to buy lollipops for 10 years? I'm just trying to figure out if this accomplishes the objective of creating the opportunity for another charitable donation and doesn't put us in any jeopardy. In council's opinion, is there any harm that could be done to the county by moving forward with the negotiation of it or the discussions regarding the elements of an ordinance that our board would have to adopt in order to implement this agreement? Either council, whoever feels like speaking up, I guess.
Well, I mean, there's some certain language that, you know, I focused in my prior comments on number 3, that we were looking for direction on that. If the difficulty would be signing an agreement that says shall be increased as follows, we could change that, all of these shalls to may, and leave it open as to whether that's going to be a continuing cost. To me, that's the best way to reach your issue of, jeopardy-free for the county. If we modify the language to there's a lot of shalls in this agreement. We took out what we thought was the most important shall to take out, the shall adopt, but there's also other shalls that obligate the county, would appear to, and I wouldn't want to have the CEO sign an agreement that said shall, and under the theory I had that I meant may, because we still had to consider the ordinance. I wouldn't want to, mislead Mr. Tarrant either, that all of those issues are open.
Understood.
And is this the type of stuff that can be ferreted out within the next days.
I'll have to-
From a county CEO standpoint, I see no reason they cannot be ferreted
And
out.
I just briefly went through it, and it looks like there's, you know, a lot of housekeeping changes, nothing major here. But the fact that this wasn't provided, you know, that I have a concern with it, but I'm not so concerned, having read it myself, that there are some things in here that we can make adjustments to within the next couple of weeks. So, you know, that being said, I'm still where I was a minute ago.
Okay.
Yeah, I was, yeah, you know, and with the motion here, that Kirk made, I would include, some other language substantially in the form of what we see here, to give us the latitude to make whatever changes we need to make. Does that,
That's fine with me.
Jerry,
Well,
you're on.
as long as the board is satisfied with the illustration I made, we will look through the agreement just to confirm that there aren't obligations, that they're all to be determined through the ordinance process for setting the fee.
If I could ask Mr. Duran, are you authorizing the county executive or another county officer to execute an agreement as part of that motion that's consistent with the principal terms of this draft?
I suppose what we're doing is asking them to bring the agreement back for us to adopt and for him to sign. Is
And
that's what I understood?
Yeah, I don't believe you meet again before the end of the year, though, do you? No.
But we do have the ability to have a special meeting, correct?
Yeah.
That'd be the cleanest way.
Yeah, I think it needs to come back to the board.
So with that, Madam Chair, rather than considering this motion today, is there the willingness of the board to meet again next Tuesday for the purpose of taking up this item and give staff the opportunity to meet with
I don't
the applicant on this?
on my phone. I can certainly look at my calendar. I don't have my phone in front of me, so I don't know.
Look at my calendar.
I know it's the 18th. I don't know what I'm doing on the 18th. Yeah, no, I think that's fine. I
Just
mean,
for the record, if I can say, that this is kind of what happens when things come and are kind of, you have a 1 gallon bucket of water and you try to fit 5 gallons of water in, and, you know. Or something else. Yeah, so, you know, I wanna, I'm in a very difficult place here trying to, accept the donation, but at the same time, I've got these other concerns that I'm trying to protect and evaluate, and hopefully, I know you appreciate that, Tim. So, that's the motion, I guess.
So, yeah, Madam Chair, I'd withdraw my previous motion with the consent of the second and move that we take up this item next Tuesday at 9 o'clock in the morning for consideration.
all right, we have a motion and a second, and that one was really simple. All in favor?
Aye.
Any opposed? Any abstentions? Okay, great. Having completed all business, we stand adjourned.